Hello, everybody, and welcome back to the channel. I'm attorney Vincent W. Davis, and today we're going to discuss a topic that affects thousands of California families every year. And that topic is this: how to prepare for a California divorce case without making costly mistakes. Now, if you are thinking about filing for divorce, if your spouse has already filed, or if you're somewhere in the middle of the process, this video is for you. Divorce is not just a legal proceeding. It is often one of the most emotional, stressful, and financially significant events a person will ever experience. And unfortunately, many people make decisions early in the process that hurt them later. They fail to gather records, they communicate emotionally, they hide assets, they ignore deadlines, or they walk into court completely unprepared. Today, we're going to talk about how to avoid those mistakes. We're going to discuss California divorce law, family court procedures, evidence, financial disclosures, custody issues, property division, spousal support, and what happens if you disagree with the trial court's decision. Most importantly, we're going to discuss practical steps you can take to protect yourself and your family. So let's begin. The first thing you need to understand is that California is a no-fault divorce state. That means neither spouse has to prove wrongdoing to obtain a divorce. You do not need to prove adultery. You do not need to prove abandonment. You do not need to prove cruelty. The most common ground for divorce in California is irreconcilable differences. Now, a lot of people are surprised by this. They come into my office wanting to tell me every terrible thing their spouse has done. And while some of those facts may matter for certain issues, most divorces are not decided based on who was the better husband or wife. Instead, the court focuses on legal issues: property, debts, children, support, and financial disclosures. So, the first practical step in preparing for a divorce is getting organized. Before you file anything, begin gathering records: tax returns, bank statements, credit card statements, retirement account records, mortgage documents, vehicle titles, business records, investment statements, insurance policies, pay stubs, loan documents. The more organized you are, the stronger your position becomes. One of the biggest mistakes people make is assuming they can collect everything later. Sometimes accounts disappear, sometimes access gets restricted, sometimes records become difficult to obtain. The earlier you gather information, the better. Now let's talk about community property. California is generally considered a community property state. That means property acquired during marriage is often presumed to belong equally to both spouses. Notice I said often, because there are exceptions. Separate property may include assets owned before marriage, inheritances, gifts, and certain other categories of property. But determining what is community property and what is separate property can become complicated, especially when funds become mixed together. For example, suppose one spouse owned a home before marriage. Later, marital income was used to pay the mortgage. Now, questions arise. How much is separate property? How much is community property? These issues can become highly technical. That is why documentation matters. Now let's move into the actual divorce process. A California divorce generally begins when one spouse files a petition for dissolution of marriage. The petition is filed with the Superior Court. The other spouse must then be properly served, and right away, procedural rules become important. Service matters, deadlines matter, forms matter. Many self-represented litigants create problems for themselves simply by failing to follow required procedures. After service, the responding spouse generally has the opportunity to file a response, and then the case begins moving through the family court system. Now, let's talk about one of the most important requirements in California divorce cases: financial disclosures. California law requires extensive financial disclosure obligations. This is not optional. Each spouse generally must provide information regarding income, expenses, assets, and debts. The purpose is transparency. The court wants both parties operating from the same financial information. Failure to disclose assets can create enormous problems. Judges take disclosure obligations very seriously. And in some situations, undisclosed assets can result in sanctions, attorney's fees, or other consequences. Now, let's talk about child custody, because for many parents, this is the most emotional part of the divorce. California courts generally focus on the best interests of the child, not what is easiest for the parents, not who is angriest, not who files first. The court examines factors involving health, safety, welfare, stability, and the child's overall well being. One mistake I see repeatedly is parents turning children into messengers or using children as weapons in adult conflict. That almost never helps. Family court judges want to see parents who encourage healthy relationships with the other parent whenever appropriate. Now, let's discuss temporary orders. Many divorce cases take months or even years to fully resolve. During that time, immediate issues often need attention. Who stays in the house? Who pays certain bills? What is the parenting schedule? Is temporary child support needed? Is temporary spousal support needed? California courts can issue temporary orders while the case is pending, and preparation for these hearings matters tremendously. Judges often make important decisions based on the evidence available at that moment. Now, let's talk about evidence. Family court is still court. Evidence matters, documentation matters, credibility matters. A lot of people think they can simply tell the judge what happened and everything will work out. But courts want proof. Text messages, emails, photographs, financial records, school records, medical records, witness testimony, calendars, timelines, documentation. The stronger your evidence, the stronger your case. Now let's discuss social media, because social media causes problems in family law cases constantly. People post pictures, comments, videos, vacation photos, new relationships, arguments, threats, and then they are shocked when those posts become evidence. Assume that anything you post online could eventually appear in court, because sometimes it does. Now let's discuss spousal support. Many people refer to this as alimony. California courts consider numerous factors when evaluating support: length of marriage, income, earning capacity, age, health, marital standard of living, and other statutory considerations. Support issues can become highly contested because they directly affect finances for years. Again, accurate financial records become critical. Now let's discuss settlement. Not every divorce should go to trial. In fact, most divorces eventually resolve through negotiated agreements. Settlement can save time, money, stress, and emotional exhaustion. But settlement should be based on informed decision making, not fear, not pressure, not incomplete information. You need to understand your rights before agreeing to anything. Now let's discuss discovery. Discovery is the legal process used to gather information. Interrogatories, document requests, subpoenas, depositions, financial investigations. Discovery becomes especially important when one spouse believes assets are being hidden or income is being underreported. And yes, hidden assets become an issue in some cases: business interests, cash income, undisclosed accounts, cryptocurrency, investment accounts. Discovery helps uncover information. Now let's discuss credibility. Credibility is huge in family court. Judges evaluate consistency, honesty, documentation, demeanor, and reasonableness. If your story changes repeatedly, credibility suffers. If documents contradict testimony, credibility suffers. If evidence shows dishonesty, credibility suffers. And once credibility is damaged, it becomes difficult to recover. Now let's talk about hearings. Preparation is everything. Know your facts, know your documents, know your timeline, have exhibits organized, understand what relief you are requesting, and remain respectful. Judges notice professionalism. Now let's discuss witnesses. Not every case requires witnesses, but sometimes witnesses become important. Teachers, doctors, counselors, family members, accountants, business professionals, other individuals with relevant knowledge. But remember, witnesses should provide facts, not emotional speeches. Facts are persuasive. Now let's discuss objections. Many people are surprised to learn that objections occur in family court. Hearsay objections, foundation objections, relevance objections, speculation objections, authentication issues. Evidence still has rules, and understanding those rules can significantly affect outcomes. Now let's discuss documentation again because it is that important. Keep records, save emails, preserve texts, maintain calendars, retain financial statements, keep copies of filed documents. You would be amazed how often organized documentation changes the direction of a case. Now let's discuss timelines. Timelines help judges understand events. When did separation occur? When were accounts opened? When were payments made? When were children enrolled in school? When did major events occur? Chronology creates clarity, and clarity helps credibility. Now let's discuss trial. If settlement efforts fail, the case may proceed to trial. At trial, evidence is presented, witnesses testify, documents are introduced, arguments are made, and ultimately the judge issues decisions. Trials can be stressful, but preparation reduces uncertainty. Now let's discuss one of the biggest mistakes people make during divorce: letting anger control strategy. Anger is understandable. Many divorces involve betrayal, disappointment, and emotional pain. But family court is not therapy. The judge is there to apply the law. The more you focus on evidence and legal issues, the stronger your position usually becomes. Now, let's discuss appellate remedies. Sometimes people lose, sometimes judges make mistakes, sometimes parties disagree with the outcome. California law provides certain appellate remedies, but appeals are not new trials. The appellate court generally reviews the record created in the trial court. That means preserving issues during litigation matters tremendously. If evidence was improperly excluded, that issue may matter. If legal standards were applied incorrectly, that issue may matter. If procedural errors occurred, that issue may matter. But deadlines for appeals are strict, very strict. Missing an appellate deadline can eliminate important rights. Now let's discuss post-judgment modifications. Some family court orders can later be modified. Child custody, child support, sometimes spousal support. Circumstances change, people relocate, income changes, children grow older, new facts emerge. The legal system recognizes that families evolve over time. Now, I want to speak directly to anyone watching this who is going through a divorce. I understand this process can feel overwhelming. You may be worried about your children, your finances, your future, your home, your retirement, your stability. But one of the best things you can do is become informed. Understand the process, understand your obligations, understand your rights, and make decisions strategically rather than emotionally. The people who generally do best in family court are not necessarily the loudest people. They are often the most prepared people, the people with organized records, the people who understand deadlines, the people who preserve evidence, the people who stay focused on long-term goals rather than short-term emotions. Now, as we begin wrapping up, I want you to remember several important things. First, preparation matters. Second, documentation matters. Third, credibility matters. Fourth, understanding procedure matters. And fifth, your decisions early in the case can significantly affect the outcome later. If you are facing a California divorce and need guidance, education, or representation, we are here to help. Call us at 888-888-6582. Visit our website at www.vincentwdavis.com. Visit our YouTube channel, Davis Divorce Lawyers. You can also schedule a consultation online at www.vincentwdavis.setmore.com. Thank you for watching. I hope this discussion helps you better understand how to prepare for a California divorce case and avoid some of the most common and costly mistakes people make. I'm attorney Vincent W. Davis, and we are all in this together.